Hey folks, it's Denise Howell here, and coming up on This Week in Law, we've got Kevin Thompson, Evan Brown, and Iyaz Akhtar. We're going to talk about the new, kinder, gentler SOPA, which is called Open. Such a nice name. We're going to revisit what's going on with Google Books and book scanning, carrier IQ. Zuck's chicken winds up out in the open. Poor Zuck. Much more coming up on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 140, recorded December 9, 2011. A tweet too far. This episode of This Week in Law is brought to you by Ford, featuring available voice-activated Sync. Sync gives you versatile access to music, podcasts, and more from just about any device. Check it out in the new 2012 Ford Focus and at ford.com/technology. And by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, iPhone, or TV instantly. All streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit. Hi, folks. I'm Denise Howell, and you've tuned in for This Week in Law, where we are your tour guides to the world of internet and technology law. We have some great guides with us here today. Iyaz Akhtar there in the studio. Hello, Iyaz.
Hi, Denise. How are you doing?
Doing great. Wonderful to have you back on TWiL.
Thanks for having me.
And joining us again is Kevin Thompson, the cyber lawyer. Hello, Kevin.
Well, hi, Denise. Thanks again for having me on.
It's great to see you again. And joining us again, the once and future Evan Brown. Hello, Evan.
Hey, how's it going? It's great to see you.
It's great to see you, too. We've got lots to talk about this week. Some fun and interesting developments. Number one, some stuff going on in the Google Books case. I thought it would be fun just to take a look back at what's going on there, since it's been dragging on for years. And it seems like procedurally we may have some resolution one way or another on the horizon. The parties, just to give a little perspective, the Authors Guild and other publishers have been going after Google for quite a few years now. Maybe, Evan, do you remember, was it 2004, 2006 this all started? Sometime around then.
The lawsuit was filed in 2005. So
okay, so right in the middle.
Yeah.
And the parties have been trying to settle so that Google could go forward with its scanning project and not have this specter looming over its head. And it's brought several settlements to the court, which have not been approved by the court. So now Google's gone ahead and said, you know what? We're going to try and make this case just go right away. We're going to file a motion to dismiss. So they're going back on the offensive here. And that's all scheduled and queued up for resolution by the court in the next couple of months. Kevin, do you think this will finally and ultimately get rid of the case? Does it have a chance?
Well, that's always a good question. Personally, I think this is going to drag on for a little while longer, but you never know. I sometimes get proven wrong. I think between, that particular case, the Hattie, case with the lawyer, Authors Guild, I think this is certainly something that's going to be dragging on one way or another, whether it's this particular case or the other case.
Right. So the other case,
definitely.
The other case is pretty new. It was filed in September, and it's the Authors Guild versus the Hattie Trust, which some people have called the National Digital Library. It's the repository of all the items that Google is scanning as a part of the books project, as well as other materials too. And the Authors Guild's not real pleased with them and is sort of going after them as a roundabout way of forestalling the Google Books project. Evan, do you see anything on the horizon here that we should be concerned about or looking for the final end of all of this?
Well, even though the lawsuit was filed more than 6 years ago, procedurally, we're still just coming out of the gates on this. If what is going to be filed is a motion to dismiss, I trust that that is going to be a motion under Rule 12, like a motion to dismiss for failure to state a claim, which could be transferred into a motion for summary judgment. And I don't want to get too up into the legal nuances for the non-civil procedure wonks who are watching and listening, but my concern is that at this stage in the litigation, there hasn't been any discovery taken yet, so there's really no evidence, and this is so hard to believe because the case has been going on for so long. There's not yet evidence that Google could actually point to say, Judge, there's no triable issue here, and therefore the case should be thrown out at this point. A motion to dismiss would just test the sufficiency of the pleadings, what is actually set out in the complaint that was filed in 2005, and I guess it's been amended at least once. And at this stage, it's premature to make a really good argument on fair use. We've known all along that Google's best argument for in its defense for scanning all of these works is fair use, which is codified in Section 107 of the Copyright Act. But it's a pretty rare instance when a court will toss out a lawsuit at this early stage when there's no evidence on the basis of fair use. Now, that has happened before. In fact, that happened in at least one of the Righthaven cases. But with a case of this significance, it seems implausible to think that the court will be ready to toss it out at this point if there's no real evidence yet to go to this very essential question of fair use. And so for that reason, I think that if the parties don't put their efforts towards settlement and continue through the ordinary channels of litigation that the rules of civil procedure provide, it won't be going away soon, and it will be something that its going away will be postponed until later.
I've always been curious about this.
Go ahead.
I've been curious about this case. Now, the reason why the Authors Guild seems to be so upset is because Google's involved. Now, if you have the universities, if they were doing this by themselves, let's say one university decided to do a massive set of interlibrary loans and digitize it for themselves, and then each one did the same thing, that, even though it's a different form, would that still be allowed? Because that would be under the fair use with education, wouldn't it? Would the Authors Guild even be going after these guys if they were doing this not in concert?
Yeah, I don't think so, because you're talking about a context where it wouldn't be something that's publicly and or commercially available, right? It would be available to the student bodies of the entities involved. But what Google's trying to do here is really build a national or international digital library. And I don't know if you guys have made much use of Google Books as it exists now or Google Scholar, but oh my God, the resource that it is even now is unbelievably deep and rich. And, you know, if they get the go-ahead to keep on going, I sort of see this as where we were with search many years ago, and people were still trying to get their arms around, you know, the legalities of that, and they still are, you know, with Google News, et cetera. But Google has managed to soldier ahead and get the fair use rulings that it needs to create its business, and I think that will continue to happen here. But we seem to be once again back at that same barrier of, you know, in order to provide the world access to this information, we're going to have to get over these legal challenges. But if you've used Google Books and Google Scholar, I've been pretty impressed by the fact that, you know, if I were an author, I might be surprised that my works were on there, but I think I've not been able to go on there and say, you know, I'm going to read this whole book online, and I feel like I'm pulling something over on someone. You know, I mean, they really, I think, are hewing to using the works only enough to allow them to be searched. And, you know, again, Evan says we haven't gotten to the evidence phases, and that's what when all the uses of these tools will come into play. But from my cursory examination of the tools, it doesn't seem like Google's gone off the deep end or put itself in a real vulnerable position. Anybody have a different take on that?
I'll just be curious about, again, the works. They're going after orphan works. They can't find the copyright holders in the first place, so they're trying to digitize the ones that, not technically in the public domain, I guess, at this point, but there's nobody to pay off. So that's why I'm just like, okay, if these are the bodies of work they're going after, and the Authors Guild is obviously trying to protect its own interests, and then we should get royalties if you're reproducing our stuff. If they're going after orphan works, why is this such an issue with the Guild?
Well, because I think that's the Hothy Trust case deals a lot with those orphan works issues. And I think there's a dispute about what's an orphan work and what's not. You know, I mean, it's people are coming out of the woodwork and saying, hey, I'm here. I want to be paid.
Well, they're no longer orphaned then, I guess. And then those would be like, okay, we're not going to use those copies. I just think it's strange about the form. Like I was saying, if they weren't acting in concert, this would be okay. The fact that they are working together, that's the issue. It's kind of like...
Yeah, and there's a particular provision of the Copyright Act. What is it? Is it Section 108 that that speaks directly to libraries making digital copies? Somebody, if somebody has the actual site, I'm just going by memory here, but I know that it pertains to granting libraries certain rights to make archival copies of works in a digital format so long as certain restrictions are made. And I don't know, like I say, I'm talking off the top of my head here, precisely what those are, but I know that not among those exceptions is what's going on here, what the Hothy Trust is doing by concerting these efforts and also making it available as broadly as it is. I think there are certain restrictions in order to be in that exception, such that it's only available for scholars, and the library itself has to meet certain criteria which may not be met here. So, Iyaz, that there is a section in the Copyright Act that contemplates a situation like what you're talking about here, that it would be okay. In this situation, it's something different, and therefore there's a viable claim for infringement. But it's not the first time that we would have seen in the history of the world that a plaintiff is trying to use copyright in a way that's not necessarily intended in the mind of God when copyright was created back in the
trust me, like when it comes to the form being a really, really important issue, I mean, I've studied tax law, so I know the form can change everything, even though you have the same consequence. I just think that when when non-lawyers see these cases and they're seeing that it could be okay in one form and it's not okay in another, it's very confusing. I think to the general public, okay, why is this even going on? But when you're educated in this enough, you go, wow, I can't believe that if I did it with Plan A, it works, and Plan B, it doesn't.
Right. No, I think some things about this, though, are their strategy, though, is to digitize every book, not just the orphan works. And, they're certainly able to point to the orphan works as one justification for their massive scanning scheme. But, like you say, it gets to, the purpose and why they're doing this. And, it's to make this large catalog that's available online for people to read, and yet at the same time, that they do have some aspects of use, such as the libraries being able to scan for their purposes. And I think that's one reason they reached out to the libraries initially to help in the scanning project. Sort of make use of that. But that they've taken it one step further beyond what the people had in mind. When that section was first created, I don't think anybody had in mind, the prevalence of, automated scanners and just how easy it would be to scan a whole book, much less a library.
Right. Not to mention that going forward, you're going to have digital versions of books available from the get-go where they don't have to be scanned.
Right.
All right. Well, one thing I don't think we're going to see in that Google Books lawsuit is an argument that anyone absolutely assigned the copyrights via email. But this is something that we've seen in a case that just came out from the 11th Circuit. I think it originated from a federal court in Florida. Kind of interesting because it stands for the proposition that email exchanges can result in enforceable contracts. But the wrinkle here is not only... here did we have a contract form, but we had an artist. His name was, let's see, I jotted it down. Rafael Vergara had an exchange with Coca-Cola where he did some Spanish lyrics that were used in Coke's World Cup ad campaign. And the courts, both of them, the trial court and now the 11th Circuit, decided that he went ahead and absolutely completely signed copyright in his lyrics to Coke in exchange for just getting a credit as an adapter and producer of what Coke made. And I guess he had second thoughts about that and came back and took issue with the fact that an assignment could take place in this way, in this manner. But the court said, no, absolutely, you assigned the copyright, and there's nothing in other provisions of law that say you can't do that in email, so you're out of luck. And oh, by the way, Coke asked for its reasonable attorney's fees in the case, asked for almost $2 million, got about $600,000, but still, that's a big chunk of change for this poor unsuccessful artist to have to fork over in this lawsuit. Anyone think I'm being too sympathetic to the guy and he just needs to suck it up? You need to stick by your emails, Evan?
Well, I was pleased with this result because it stands for the proposition of efficiency in these types of transactions. It already makes everybody's life difficult enough with all the hoops that you've got to jump through in everyday life, in ordinary things. So we want to have transactions like copyright assignments, copyright licenses, not have all of these indicia of formality that people have when they, that come to mind when people are thinking about the law. It's nice to know that you can actually assign a contract without it being a huge, complicated, beat you over the head, formalistic document that you've got to not only sign, but have notarized, and then you have to have the king's ring imprinted onto the wax seal to make it binding and enforceable. It's the exact opposite of that. Even what we have here is even the simplest of writings, so long as they comport with the contract law of the state that this is happening in, be an enforceable contract. So it's a point scored for the sake of efficiency and thereby the reduced costs of actually doing business in the intellectual property marketplace, which seems to be, in my view, universally laudable.
Reverb Mike in IRC raises an interesting point and asks if this is yet another reason for an email disclaimer. What do you think, Kevin, if you just had a tag of boilerplate at the end saying, I don't intend to assign any copyrights by anything I say here, do you think that would have helped this guy out?
Probably not if you attach that to every email that you sent out. I think having that as your disclaimer for everything, I don't think is necessarily going to fly. I think the courts are going to look at the four corners of what was actually said and part of the contract. So certainly emails are valid and enforceable contract entering devices in other areas of law, and I don't see any reason why copyright should be excluded from that.
I kind of feel bad for the guy, Iyaz. I mean, I feel like, yes, if you're dealing with Coca-Cola, you should have lawyers involved in what you're doing. You shouldn't just be emailing with them and expecting the legal chips to fall where they may. But I don't know. I feel like he kind of got taken here. What do you think?
I mean, I have sympathy for the guy for getting. That lawyer's fee is pretty hefty. I mean, I don't know if he's not getting any royalties for his lyrics. I don't know how much money he's got in the bank anyway to pay off Coke, but he was emailing Coca-Cola after all. I mean, he knew who he was working with, but then again, it's just kind of like it's a cautionary tale kind of thing. I mean, if you have a contract that's written on a napkin or it's written on it's a handshake deal, those are enforceable to some degree. So why shouldn't email? I mean, this is back to the form kind of thing. If email is writing, this should work. While I feel bad for the guy, it just means I hope that people realize that when they email stuff, you could be giving away rights unless you actually say otherwise.
Right. Oral contracts are enforceable. Yeah. It's just sort of harder if there's a dispute about it after the fact to determine what the actual terms of the oral contract were. So, well, sorry, Raphael. Better luck next time.
Or always CC your attorney while you're sending out these emails. So they can write immediately, whoa. Before you accept that, this is not an offer. Just write something like that before you say, okay, everything's fine. It's like when somebody writes on their check in the memo line, paid in full. Like, oh, it's right there. It says it right there. If you just cash that check, you're settled.
Right. Well, we had Nilay Patel on the show recently, and he mentioned that the lawsuits are already starting to pour in about carrier IQ. As far as I know, there are 3 of them now, class action suits pending about carrier IQ's activities and alleging various privacy violations, Computer Fraud and Abuse Act violations, and also federal wiretapping law violations. Evan, do you think that these are going to go anywhere?
I think these are filed by a bunch of whiners, and I hope they don't go anywhere, and I hope we don't have to be talking about them for very long, because I'm just, initially very skeptical, kind of as a presumption of lawsuits, especially lawsuits that purport to be class actions this soon after news breaks like this. It smacks of just pure unguided opportunism that I don't like to see, because I don't think it benefits anyone except the plaintiffs' class action lawyers on this, and that's not a benefit that inures to the rest of society. So I think they're probably meritless for a number of reasons. The biggest one is these claims tend to be focused mostly on what they're calling in the press, and some refer to it in the complaint as the Federal Wiretap Act, more specifically the Electronic Communications Privacy Act. And that provides a civil cause of action. It's actually in the criminal code of the federal statutes, so the U.S. Attorney's Office conceivably could file some criminal charges here, but that probably won't happen because they're fighting the war on drugs and stuff. But what the civil cause of action provides is a remedy against the unauthorized interception of electronic communications by another, or the disclosure of the information, the communications that are intercepted. And there's a very clear exception to liability for the actual, the service through which these communications are made. There's an exception for the liability when that provider is the one who's doing the intercepting, or doing the seeing what kind of information is going through here. Not only is the provider itself immune from liability, but also its agents are immune from liability. So unless there's just something really unless Carrier IQ truly was doing something renegade here outside of the scope of the authorization it had pursuant to the contract it had with the carriers or with the manufacturers or whomever, it sounds mostly with the carriers, then it seems clear that they were doing the work of the carrier, and I haven't seen anything to suggest that they were doing anything other than that. The rest of it just seems to be speculation. So I think that in as much as these cases sound under the Electronic Communications Privacy Act, that defense sounds pretty good for the carriers. There's also, some breach of contract claims that may or may not pan out. Who knows? It seems like the disclaimer language and privacy policy consent language in most of these services agreements is generally written so broadly it would cover something like this. The Computer Fraud and Abuse Act claims, I've said this a number of times on the show, I think those claims are going to be sunk because I don't think there's the articulable kind of damage that the Computer Fraud and Abuse Act requires, because this is not, I don't see how there could really be any true allegations where what Carrier IQ was doing diminished the performance of these little machines that we carry around with us here. So that all said, those, that what I just said about the legal merits as I see it is, of course, all under the heading that I started off my little commentary on here with. I just generally think that these are opportunistic lawsuits that don't really help us all out at the end of the day. So I hope they go away and we don't have to be talking about it very, very much longer.
Right. It's a little bit like, if I can make kind of a weird analogy here, someone like Viacom going after YouTube instead of the people who are uploading to YouTube. They're going after the intermediary here, Carrier IQ, as opposed to the carriers who are the source of the gathering of this information. They say they're doing it for network quality issues and that they've covered themselves with their terms of service. But if people are really getting surprised by this and feeling like they've been violated, I think they're pointing the finger maybe in the inappropriate direction. What do you think, Iyaz?
You know, I'm with Evan on this one. I mean, suing carrier IQ is one thing, but I know that there are a number of suits against some of the carriers too. And you know, I remember I was reading the actual Sprint privacy agreement, which I'm sure nobody does, and they are written incredibly broad, and they don't enumerate exactly every single diagnostic they can send out. But they do say things like, we'll send out your location, your IP address, we'll check what websites you've been on, how you got to where you are, like all kinds of things that if people actually read these things, I don't know if they would freak out or go, you know what, I don't care, I just want this phone on this service. I think this is it's just part of a larger problem that nobody ever reads anything that's either a pop-up on their phone. They don't read the warnings that show up on a computer. They don't read the privacy agreements that they're agreeing to. And I mean, this is like, there was a story today, and this one just drives me bonkers. People were complaining to Coca-Cola that they were confused by the white can of Coca-Cola. They're confusing with the silver can of Diet Coke. Now, the Coke logo on the white can is about half the size of the can. So if the text is in 50% of the actual thing, they still can't read it. So I don't know how anybody's ever going to read a privacy agreement from Sprint or AT&T or Verizon, whoever is involved in this case, or even if Carrier IQ said on the front of your phone, it said, we are tracking you, like in giant font. I don't think people are going to read this. They're going to be like, I want to play with the Android market now. I want to play with iPhone now. And they're not reading it. So it's just so silly at this point that I don't know how it's even possible to educate a consumer other than like forcing them not to leave until they, I don't know, look you in the eye and say, oh, I understand. And even that I don't think is enough. I'm just confused. I don't know where do you go from here?
I don't know. Kevin, any ideas?
Well, you know, there are, you know, plenty of good points that I think Iyaz and Evan both raised there. You know, I think the last time I looked at one of the agreements, I think it was 45 pages long, and it just I took started going through it and I gave up. I just hit the button accept. Sort of a bad thing for the lawyer to acknowledge there, but
you're held to a higher standard, you know that, so you're bound.
That's true.
You're bound,
well, right? True, but you know, I did want to use the phone, and you know, but by all means. You know, I thought for a second, for reading some of the news on this, that we'd have another Apple, some sort of privacy gate or something like that. But you know, even then, they acknowledged that they only had used it on prior versions of iOS, and it wasn't you know, it wasn't part of iOS 5, or at least part of. I don't think they were totally clear about which old devices still were running iOS 5. Maybe the 3GS was still using it or something like that. Who knows? But you know, you look at the hard coding and what exactly that Carrier IQ did, and it certainly is not a terrible thing. I think a lot of it's much ado about nothing. And people should be aware that they're using it. Obviously, Apple had the good point of if you're going to use the phone and submit this data in, it was something you had to acknowledge and say yes to when you initially set up the phone. I don't think all the carriers did that. I think Verizon certainly didn't. But it's. I don't know. I think I agree with Evan that these class action suits are way too early. Everything is really speculative at this point as to what their damage might be, and I also agree with Evan that this certainly isn't going to be rising to the level of damage that's required under the Computer Fraud and Abuse Act. $5,000 was the damage to your phone.
Yeah.
Right.
Evan, do you think that this adds incrementally or at all to the ability of law enforcement to get at this data? They can already, obviously, get data from the carriers. I guess maybe this might give a more organized and or comprehensive database to draw from. So there might be privacy and or other constitutional concerns there, Fifth Amendment kind of concerns at all.
Right. Yeah, I mean, those are extremely important concerns, but I'm not sure that there's anything new here. When I just become introspective about this and think about my own subjective expectation of privacy when it comes to the contents of, for example, text messages that I send or the location data that I have. I am aware that information is somewhere in the hands of the carrier. I don't know exactly for how long. I could probably find out if I, read a portion of the terms of service or maybe made a phone call or sent a certified letter or something. But, I'm not so naive as to believe that the carriers and their agents, whomever they may contract with to provide the service, I'm not so naive as to believe that information does not exist somewhere and that it is, in theory, extractable, obtainable, whether it be by the carrier itself for network performance or by law enforcement pursuant to, let's hope, due process. So the only thing this really does for me when we start thinking about these things is remind us that this is a concern. That's something that we torture ourselves over, thinking about what is the interplay between the Fourth Amendment right of privacy that we have, or the Fourth Amendment right to be secure against unreasonable searches, more precisely. What is that right that we have here, and how does that interface with the fact that all of this information, which the founding fathers characterized as our persons, papers, and effects, those things now are stored on a third-party server. So I just don't see really how this, if we think about this sincerely enough, how this should be making us any more scared about our individual civil liberties than what we should have been before any of us, a couple of weeks ago had ever heard of carrier IQ. Right. I would be happy to hear whatever's new.
It seems like we're getting to a world where, people are almost expected to have that Scott McNeely mentality of you have no privacy, so just get over it. Or, I'm reading Ream D by Neil Stephenson, and there's a big section about people who go off into the Idaho wilderness and live off the grid and have lots of weapons. So, you're sort of left with those alternatives.
As if those things always have to go hand in hand, whatever.
Yeah. Now, I mean, a lot of this is because the marketplace is so limited when it comes to selection, right? I mean, if there was actually a carrier out there, let's say like an MVNO pops up, and they're like, look, we are the privacy network. Everything you do on your phone, we're not tracking. All we're doing is we track your calls because we check your minutes, and we track your texts, how many you do, because that's how we get paid. If there was actually enough of a demand, and if people were really super upset about this, I'm not just talking about the people who are part of this class action, but if everyone was really paying attention to this and they actually made a movement, they go, look, I'm not going to use AT&T, or I'm not going to use these companies that are using carrier IQ. It's like there doesn't appear to be enough of a market reaction to cause a competitor to show up. Because I know we were talking about this on Windows Weekly. There was an alternative to Facebook out there. It's called Unthink, and it's about data portability, and it's all your data. You get to keep it. And, nobody's on it. There's, 800 million people on Facebook, and about half of them get angry about the privacy concerns. But if there's enough, groundswell, if people get enough anger and they actually move away from some of these services, that's a hard life to do. It's like, okay, you know what? I'm not going to have a cell phone. I don't have a cell phone. I personally don't. It's not because I have a privacy concern. It's just because I'm cheap. But, I mean, people have to make a move away because that's the only way you're going to hurt these carriers. I mean, you can sue them all you want, but they're going to say, hey, by the way, did you notice that in your terms of service that you can only do arbitration? Yeah, so you're out of here. So, I mean, it's really about the market reacting, and I just don't see it happening yet.
And, even that may not be viable. I'll warn everyone, I am completely unqualified to make the statement I'm about to make, but, how's that ever stopped me before?
That's what TWiL's all about, Evan.
Right. I have a feeling that, if there were such a market that sprang up when it came to the mobile network industry that says, hey, we're not going to track this stuff. I bet you this is the part that I'm totally unqualified to say. I bet that service would really suck. Because there's so much that has to go into maintaining the quality of that network, so much diagnostic stuff, so much knowing about what actually is happening within this system, that if you were blind to that and didn't collect that information, it just seems like that would, calls would always be being dropped. It would make AT&T look like something reliable. That's just what I'm thinking. Some of this actually. as a necessity.
If you compare that to something like the Onion router, where like you can anonymize your IP address by using a series of nodes and things like that, it slows down your speeds and everything. But some people are willing to put up with that for the anonymity, so they're not being tracked. If they're in, some people always put Tor together with BitTorrent, like, oh, you're stealing things. It's also used by dissidents and people who want to avoid being persecuted in their home countries. So I mean, like, you might be willing to pay for, or you might be able to put up with dropped calls and slow service if you actually have some kind of like secure feeling. I mean, I think some people would be willing to do that, but then again, there has to be enough. It has to be a viable business for it to ever work.
Yeah.
Yeah, and what I keep seeing in comments in IRC is this issue of, we're dealing with monopolies. There's very little choice about all this. People are uneducated, as you said before, Iyaz. And these contracts that you agree to with your cell phone, I think you were saying this before too, Iyaz, they're not very apparent. They're certainly not easy to read. Who knows, I don't even remember, I use an iPhone. I don't even remember agreeing to terms of service related to the iPhone. I mean, I know that when they update the iOS software, there are frequently things you have to click OK on. But, you get that phone out of the box, you start using it, and if there is an agreement in that process, it's so subtle as to be, you can miss it readily.
Maybe
and it's accompanied. It is accompanied by that euphoria, which makes you completely incapable, you cannot form the mental capacity to assent to a contract when you have that euphoria of this new device.
You're in the right mental state to form a contract when you buy an iPhone.
The Apple reality distortion field.
I would love for one of us to go into one of these stores and go, listen, print out your entire agreement, and then we start striking out things, and then go sign it. Let them sign it again. I would love to see what happens, because I know certain companies, I mean, like you can like it's one thing if you want to exchange a shirt at the store you didn't buy it from, but if you were at the Verizon store and you were just going, I don't agree to this or that, and then sign it, I would love to see what the manager does, because that would be like a huge story. Like, a customer does not agree to this term.
They'd have security on you before you could, finish writing.
They're like, we refuse to give you service. End of story.
Yeah. Beatmaster says the newest version of iOS doesn't let you start using the phone before you agree to the terms. And, that may well be. But as I'm saying, I don't think people even notice it. It's just a process of, I got to import my email. I've got to do all this other stuff before I can actually make this device useful. And it's just one of those steps. And I don't think it strikes people that they're actually agreeing to things that might affect their privacy and or evidence gathering against them further down the road.
I mean, what's nuts is that Apple gives you the option to email yourself the EULA, or you can print it out when you see the EULAs, and it's like, whoever exercises that. Does anybody ever do that? I email myself the EULA so I can read it later and remember. It's like, it's never going to happen.
Yeah, my printer doesn't contain that much paper in its tray. Well, we're in episode 140 here, and we can't have that without talking about Twitter in the show. We've got a couple of good Twitter stories to get our teeth into. But before we go there, I want to thank our first sponsor for this episode of This Week in Law, and that is Ford Tech Entertainment. We have many entertainment features available in Ford Sync. It lets you access music and podcasts from most devices, including iPods, mobile phones, tablets, or flash drives. And sync with My Ford Touch, you can also play videos and display photos from your digital cameras or portable game devices when your vehicle's in park, of course. You don't want to be doing too much of that while you're driving. But as I can tell you, for anyone who is a parent and has their children on board for long trips, this is a lifesaver kind of a feature. It's all made possible through a versatile media hub, which supports a convenient variety of devices for your music and entertainment, such as wired connections from just about any device, USB ports, SD slots, and RCA jacks, or wireless via Bluetooth from Bluetooth-enabled devices. You just connect your devices and play. And I like that concept so much better than what we've seen in cars over the last decade or so, where folks would, put these headset displays in the back seat or maybe dropping down from the ceiling. But then you're tied to whatever technology was built into the car when you bought it. With Sync entertainment services, whatever device you're using at this point that is meaningful for you for entertainment, it's likely to plug in and work with your car. Once your device is connected, you can use Sync's voice activation feature to play what you want. Just a few simple voice command samples are, with whatever music device you're using, you can tell it to play genre, rock, play artist, and play track and insert the song title. Also available is Sync with My 4Touch HD Radio. This features iTunes tagging, which lets you tag a song you like on the radio, transfer that information to your iPod, and purchase the song directly from iTunes at a later time. Sync's versatile entertainment features are available in the 2012 Ford Focus, and you can learn more about this and other technologies Ford is bringing to its vehicles at ford.com/technology. We thank them so much for their support of This Week in Law. All right, guys, so episode 140, Twitter. We've got another example. We were talking about email before being no exception to contract formation. Apparently, Twitter is no exception to the ability of someone to come after you for false advertising. Spirit Airlines was marketing through tweets a $9 fare, but it turned out to not have disclosed the fines and taxes and various other conditions that applied, all that terrible stuff that you hear and ignore lots of times at the end of television and radio ads. You can't really do too much of that in a tweet when you're confined to 140 characters. So Spirit just was advertising its $9 flights, and it got slapped on the wrist and fined for it because it didn't include enough information. Evan, what do you think about this? Is this fair to advertisers when the medium is so constrained?
I'm glad that you said slapped on the wrist, because I actually did a little bit of research. Given the fact that I had no idea what the cost of jet fuel was like, I was trying to figure out how much jet fuel 50 grand will buy you, because I was trying to put this in, trying to gauge the severity of the fine to Spirit Airlines on this, and it turns out it's not much, according to my calculations. And I didn't show my math, and I did this arithmetic a couple of weeks ago whenever this came out, and so I just have the final numbers here. It's about between 4 and 5 cross-country trips on a average sized jetliner. So it's not a huge hit to Spirit Airlines in the overall scheme of things. With setting that aside, looking at the actual legal issues here, and the way that you've characterized the question that you asked me here, is it fair given the constraints of the medium through which Spirit wants to speak and advertise its offers here? Sure, it's fair. That it's no secret that Twitter is a medium that only affords one to speak concisely. I don't think that comes as news to anyone. And if the advertiser is going to choose to communicate in that way, it must inevitably accept the risks inherent in doing that, in as much as the risks pertain to the absence of those things which you cannot meaningfully disclose only in 140 characters. So if there really is deception going on here, and then I trust that it was less than perfectly clear what this was all about, then it seems perfectly meaningful to me to not cut too much, to not be too lenient to the advertiser when it has made an eyes open kind of choice to use Twitter as an advertising medium. So go ahead and fine them. It should have been 100 grand.
All right. All of this is it makes me roll my eyes and just go, what sort of world are we heading for? We already have these incomprehensible email disclaimers that get thrown at us all the time. Now we're going to see, as though there's not enough noise on Twitter, companies throwing in their various CYA tweets in addition to whatever it is they're trying to put out as their promotional message. Am I viewing this forthcoming apocalypse correctly, do you think, Kevin? Well,
that they will definitely need to be cautious, I think, going forward. This is certainly, I don't think $50,000 is done to, necessarily be a punishment, a major punishment for Spirit Airlines, but I think it's been a deterrent for other companies out there just to be careful looking at their terms so they're not deceptive. If it doesn't fit in one tweet, well, then send 2. One, market as 1 of 2 and 2 of 2, whatever you need to do to, get what you require, put it out there. I think just needed to put people on some notice that this was problematic, that it's more than just $9. I think one reason, if you read the article, that they got in trouble was it wasn't the only medium in which they were advertising these fairs in that way. They also had some issues with their billboard ads as well. And there, I think you're even more limited because it's really hard to fit a whole lot of text on a billboard anyways. People tend to use those when driving, and your attention span is limited to maybe 20 characters.
Yes, fine print is not very meaningful on a billboard. Iyaz, any thoughts on this?
Right.
Yeah, I mean, back to what Kevin was saying, there's more to the story. I mean, the thing is, when you click the Twitter link, you still saw the $9 promotion, and it's not until you clicked again that you saw the extra fees. So, I mean, I could see, not necessarily seeing a bunch of Twitter spam, but when you click that link right from Twitter, it should take you to something that discloses everything up front. So it's going to be like, not starting at $9 plus, and a big asterisk that leads to a bunch of incomprehensible nonsense at the bottom of the page. But it'll still be there. It'll just be on the first click. I think that'll be the big thing. Or it'll be like, oh, we've also included in this asterisk, we've integrated all these other terms. I can imagine that. But it might be in the bio of Twitter. It's like everything said here is subject to this privacy, to this disclosure. Please click here.
Mm-hmm. Yeah, it was a few years ago, and I haven't tracked whether eBay has kept on doing this, but they were live tweeting their earnings calls. And as a public company, the disclosures that you have to make around that are pretty amazingly huge. And yet they were managing to do it with Twitter. And they would put in, a stream of tweets going, we've got to tell you this, 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 and this to make sure that we're not getting in trouble with the SEC. And they would link back to other more extensive material on the eBay site, and then they would get into the call, which, seemed to make sense. So hopefully Spirit will get its act together, and I wouldn't want to be on one of those 5 flights that got canceled, Evan, because of the fine.
That's right.
We've got down in in Arkansas, we've got some jurors who were both tweeting and sleeping. So, you're either so alert that you're telling the world about the case, or it's completely put you out. Unfortunately, I'm making light of this. This was a death penalty case, so severe crime, severe punishment. But it was set aside, the death penalty determination, because of these juror activities. So it seems like yet more evidence and testimony to the fact that the court system and social media have an uncomfortable relationship with each other. Kevin, did you look at this, and what are your thoughts?
I did look at that. I thought it was a good approach by the judge in this particular case. They couldn't say for sure which 5 minutes the juror was sleeping through. It may have been important, may not have been, but that's a sort of harm, especially in a death penalty case where it certainly doesn't hurt to have a new trial for that particular instance. And so certainly the juror that was tweeting should have known better. I believe it's fairly standard in most courts these days where there's any potential for jurors' deliberations that that they must not deliberate using any means whatsoever, including Twitter, before they reach the jury room. And it certainly was a public forum, and that juror chose to avail himself of to put things out there. A lot of people don't realize that when you send a tweet, it isn't just to your followers; it's to goes into the live Twitter stream, and anybody can see that. And unless you're sending a direct message, that's what happens. And so it certainly is a very public forum, and I think that certainly was a good approach by the Arkansas Supreme Court.
Evan, do you think that defense lawyers everywhere are hailing social media as their last-ditch salvation for their clients if things go the wrong way?
Yeah, I mean, you see it tossed in as kind of the Hail Mary approach, not only in in situations like this, trying to get a verdict overturned, but you see a lot of cases where the defense lawyer is claiming that the judge made an error by not, for example, allowing into evidence photos from their MySpace page or the MySpace page of the victim. That's a pretty common argument that's made. It's like, Judge, you didn't get a chance to let me show how I'm not responsible for this crime because the victim was doing such and such. And the judge says, well, that's not relevant or what have you. So there's no doubt that this is still an area where the rules of evidence and the rules pertaining to how juries should conduct themselves are not well settled at this point. So it's one of those things where it would probably be ineffective assistance of counsel to not raise it, especially if you have a client who has been sentenced to die. So that's like that a lot. When it comes to the reality of it, you wonder in this situation how much it actually was affected. And as for the guy sleeping, I'm not sure what difference that should make. I know for myself, I'm sometimes much better at taking in facts when I'm asleep than if I appear to be fully cognizant of the person who's talking to me, and I may have no idea what they just said. So,
yeah. As we used to hear about people playing the race card in court. Now it seems like the social media card is what's there waiting in the wings.
It's the distracted juror kind of concept. I mean, it's a lot easier to say or to prove that somebody was, well, unconscious or is tweeting. But I mean, like the idea that it's great in this particular case. I mean, this is some serious penalties. This is the death penalty. So this isn't like, oh, it was a trespass case. But I mean, I've been on a jury before, and I've seen incredibly disinterested people on these cases. They're either goofing off on their phones or they're writing notes. And it looks like they're writing notes, but they're drawing little cartoons and things. But these aren't things that are examined much by the judges. They don't go into the where we deliberate and go, oh, look, you weren't paying attention. I mean, to try to get 12 people on a jury in the first place is very hard. And to get 12 people to pay attention on a jury is another issue. So it just I guess in this case, it's good that there was a very ascertainable thing. And, oh, yeah, you tweeted or you were asleep. This is not the behavior that should be accepted, I think, in a jury.
All right. Well, having talked about the impact of Twitter on the court system, we know that Facebook recently got into the same kind of situation as Google, where they're subject to 20 years of scrutiny from the FTC over perceived privacy transgressions. And hard on the heels of that, poor Facebook, they just seem to be the privacy train wreck that can't end. They have a bug come up this week that let people view photos that were otherwise supposed to be marked as and considered by their uploaders to be private. And the bug had to do with if somebody wanted to report one of the photos for being inappropriate, having nudity or whatever, as soon as you opened the reporting tool, you gained access to that person's other photos, including Mark Zuckerberg's, who had some images of his own that were meant to be concealed in private, put out on various photo sharing sites. And of course, they quickly clamped down on that. But once Zuck's photos got out there, that certainly must have amped up the fix process, don't you think, Iyaz?
I think the one that was going around was him holding up a chicken or something. He's been doing this weird thing where he only eats what he kills. Right. And I guess it's not weird. I guess that's what he's chosen to do. But I mean, Zuckerberg's photos being up there. I mean, it's just another one of those simple things. If you don't want your stuff out there in public, don't post it on the internet. I mean, I don't know where there's a really safe area on the internet, like a service like Facebook. But if I remember right, when you would I guess exploit this bug, you didn't always get access to some of these private photos. You could in some situations, and obviously the most famous one now is Zuckerberg and that picture of the chicken. So. It's at least they shut it down right away. I'm sure that the fact that it was Zuckerberg's profile that was available, or some of his photos were available, probably was a I don't know, catalyst to get this thing taken down so fast. But at least it's fixed, or it's going to be fixed.
Right. I guess the reporting tool is under scrutiny until it's functioning again, and in the meantime, I guess we'll have a lot of nudity and inappropriate photos that are going unreported. Evan, what do you think of all this?
It's an interesting evolution of a norm that we had grown accustomed to in what we've, for the last few years, called Web 2.0. I don't even think I've said Web 2.0 in like at least 2 years. But, if we're assuming that we're still in the age of Web 2.0, one of the sensibilities of that is release early, release often, fix the bugs as they occur. That's certainly a mentality among startups who are, just releasing code and releasing these products. They'll worry about sorting them out later. I see the evolution that I see in this, which is interesting, is the maturing of that notion in the way that notion, in the way that is maturing, cuts less slack for companies who have grown so big that they ought to know what they're doing. Facebook, because it's huge, because it would be the world's third largest country and all that stuff, it ought to know what it's doing. And so it's not as safe for someone in its shoes to be releasing tools like this without having been as thoroughly vetted as humanly possible, and thereby, because of that, suffering ill privacy consequences like this. There's a certain similarity to the kind of the meme that's been going around, or it's not a meme, I guess. It's the discussion with Siri and Siri's sexism that's been tossed around. I see a certain connection with that. Now, I'm not going to say that Apple is a startup, of course, but this idea that they launched Siri in beta, and now that it is subject to these criticisms of it being sexist in some of the results that it will provide, they're trying to say, oh no, it's still in beta, cut us some slack here, we're working out the bugs. That just doesn't hold water with companies like Facebook and Apple anymore. And that's the interesting side of this that I see, is we have less tolerance for this technological experimentation with companies who should know better. They're held to a higher standard, I guess, is the short way of saying it, and that's something that we need to get used to, I suppose.
Kevin, did this surprise you at all that Facebook had a privacy bug? I guess that's kind of a loaded question.
Oh no, I'm not surprised. It's the fact that the site runs at all, because of the mishmash of code that went into its creation, and the sheer number of users that they have. The fact that it runs at all is it's a modern miracle. But it has. Yes, that they launched a new tool, and I suppose the difference between them and Apple is Apple is quite upfront saying that Siri is in beta, whereas they were rolling out as Facebook, and this is our new feature, and didn't quite put the beta tag on it. And what do you know? They couldn't anticipate all the issues with it, and there were bugs. And it's to their credit that they're going to fix it right away, but. I'm certainly not surprised. The one thing about those photos, I was sort of surprised that Zuckerberg did such a good job killing that potato that was there next to his chicken. So.
Yes, and he could eat it then because he killed it himself. So that's definitely good for Zuck's rounded diet. Well, I guess we can't have an episode of This Week in Law without getting into SOPA, which I want to do in just a minute here. But first, I'd like to thank our second sponsor for this episode of This Week in Law, and that is Netflix. And I just can't tell you guys, Netflix really comes into its own for me during the holidays. It's useful all the rest of the year, but we've got it on nonstop here. At this time of the year, because I find that, rather than just tune into whatever's on Nicktoons or Nickelodeon, my child would much rather just go on Netflix, go to their holiday section, and click his way through everything there that doesn't have commercials and is, instantly available to stream to any device that he or we might be using. It has thousands of TV episodes and movies that it can stream to you instantly, saving you time, money, and hassle. There are several easy ways to instantly access these streaming movies and TV shows. You can watch on your Mac or PC or iPad, on your iPhone, and some Android phones too. If you have a gaming console, you're covered there. PS3, Xbox 360, Nintendo Wii, all of those will bring Netflix into your home. If you're not a gamer, there are great other devices available. The Apple TV, the Roku are inexpensive and easy to use. And the things just show up like magic. I mean, the way that they have managed the bandwidth in this service, you're not sitting around waiting, where's my show, or knowing that you're going to have to order it and then come back in half an hour. It comes right in instantly. You can begin watching on one device. It's wonderful. You just pause. You get up, you do something else, you do a couple of episodes of This Week in Law, and then you go back to your device, and it may be your iPhone or TV elsewhere in the house, and boom, you're good to go and pick up right where you left off. Whichever way you choose to access it, you can watch as many movies and TV shows as you want, anytime you want, and you can cancel anytime. I really can't recommend the holiday section enough. We found great things that I never would have watched ordinarily. There was a really funny ancient movie with young John Lithgow and young Dudley Moore. I forget right now what it's called because we've had such a flurry of Christmas stuff going on. But it was really cute and entertaining. My son loved it. Great version of the Nutcracker there. So lots to check out and enjoy during the holidays there on Netflix. And if you're not already a member, you can get it 30 days for free right here in the holiday season. Go to netflix.com/twit. When you use this URL, when you check out, it lets them know that the TWiT network sent you there, and we appreciate your help with letting them know that. And we thank Netflix for their support, and we hope you enjoy watching instantly with Netflix. All right, so we've got a couple of SOPA-related things to talk about. First, Larry Downs was on the show with us not too long ago, and he is a real scholar of this legislation now, I guess we'd have to say. He's actually a commentator over at CNET and Forbes and elsewhere. He's got a great piece about the compromise legislation that has been introduced by Ron Wyden and Darrell Issa that may be the middle ground that people have been looking for. It's called the OPEN Act, Online Protection and Enforcement of Digital Trade. It is supposed to stand for. And Larry has taken a look at it and thinks it strikes the appropriate balance and basically answers the demand that people have been putting out there for a more reasoned approach to addressing these problems. Evan, do you think that Open does the trick, and does it have the chance to get the traction that it needs to be the solution here?
Couple of observations off of the top here. First of all, I imagine there is an independent body of study that has to do with the naming of these acts. Don't you love this example of it, as opposed to SOPA, which is, at least if you're confining your analysis to the English language, which is nonsensical and kind of silly. But and that act, of course, was subject to such scrutiny and negativity. And then in the Senate, you have Protect IP, as if, this is the RIAA's bill and all that stuff, because, we, of course, are pro-IP from the get-go. But open, isn't that such a nice...
How could you not like open?
Connotation. Yeah, it's just so West Coast.
Protection and enforcement. What could be wrong?
Well, you see, that's the part that's hidden within the nice connotation of openness. It's just protection and enforcement. It's all badass, but it's all open. So that has nothing to do with the substance of the law. But what I guess what I see here is that, because it was Ron Wyden, because it's all West Coast like that, it's probably a good thing. We know that it's certainly going to be much more sensible from a technology perspective than what SOPA and Protect IP would, have in them. What we see, the essential difference, it seems to be here, is that enforcement is taken out of the hands of the Attorney General, Department of Justice, and also out of the courts to only private citizens, and they have to go through the International Trade Commission, which is an agency in Washington, D.C. So the remedies are pared back. It's much more focused on foreign websites. It doesn't sweep into the scope of its power as readily, legitimate domestic websites, which, of course, as, Lamar Smith and others who are behind the more draconian legislation that's currently passed, just kind of say offhand, this is, of course, just only to target criminals. We all know that it's overbroad. SOPA and Protect IP are overbroad. So it's more sensible in that respect. So I like it. It's a good alternative. The only concern that I have about it, and don't get me wrong, I don't think this is a really bad concern, but I think it's worth thinking about, is this really the direction that we want to take power like this and put it more in the hands of the federal government bureaucracy? I don't mean to sound all Ron Paul about this, but it's just making the federal government bigger. And Larry Downs in his piece said that this wouldn't require any expansion of the federal government, but I don't see how that really is, because if I am an aggrieved party now and I want to seek relief under the Open Act, if it is undertaken, I'll have to go and hire a lawyer in Washington, D.C., who's going to have to file papers in Washington, D.C., whereas, I could have otherwise had the ability to just file an action in district court, wherever I am, to do these types of things. So that's the only, commentary that I have about this. It still seems sensible enough. Otherwise, the only way that I could see to improve on it is to kind of take the pared down, ham-fisted remedies that are in SOPA and Protect IP, take those the way they are now in the Open Act, and think a little bit harder as to whether we really want the International Trade Commission to be the only place where one can go about and get these remedies. It's definitely better than the other acts. And it's obviously in the right direction, much more sensible for the technology perspective.
Right. If you're an ITC lawyer, I guess this seems like a really good idea.
Maybe we should think about all becoming ITC lawyers. We could take a CLE or something about how to practice in front of the ITC. That's that's maybe the wave of the future.
It's a pretty obscure branch and very specialized branch of practicing law. Iyaz, do you think that this is going to be the answer to all of the controversy?
I seriously doubt it. I mean, the thing is, the bar set so low with SOPA of how incredibly broad it is that almost anything would look better, and Open is actually pretty well thought out. As to Evan's concern with the ITC, and you have to do everything in Washington, D.C., it's kind of like, it reminds me of when being a patent attorney was a cool thing. Like, I mean, it still is now. I mean, for a while, it was like, oh, this is kind of like a fringe thing, but it exploded with technology. So you had a lot more patent attorneys coming out, and if you wanted to even be a patent attorney in school, you'd decide to have a science major instead. I mean, it influences a lot of things. And considering the job market, I don't think it's half bad to have people going into the ITC because it was pretty harsh out there, at least when I was trying to get a job a couple of years ago. That's how I ended up here, actually. Not a lot of law jobs out there.
That's right. If there's a silver lining to the bad economy, I think we just found it. Kevin, what do you think about Open?
Well, I certainly think it's better than SOPA. I think SOPA is definitely overbroad. There was a great piece that Mashable had the last day or so about a nice infographic about SOPA. I thought it was well worth looking at. I don't know if people have a chance to look at that, but I was thinking about posting that to the blog. I just haven't gotten around to it. But Open is certainly better on first glance. I think some further look at it is in order. But just because it's better doesn't necessarily mean that you necessarily want you want to enact it just because it's necessarily better. I think legislation should be looked at in its own terms, and maybe something lurking in the Open Act that if on more careful review could come out. But at first glance, it certainly sounds better, and I certainly hope that something along those lines is enacted rather than something like SOPA.
All right. Well, we are glad that development has occurred. We're going to go ahead and give you our tip of the week and resource of the week. Our tip comes to me courtesy of Johannes Ernst at Project VRM, the mailing list that Doc Searles started over at Harvard and the Berkman Center that works on vendor relationship management is what VRM stands for, and is all about people being in control of their data and the things that are harvested by the various companies that they work with. One company that gathers a lot of information from people is 23andMe, and Johannes gave these folks some kudos and applause by poking at them a little bit. They sent him, I guess he's done the 23andMe thing where you scrape the inside of your cheek and send them a bit of your DNA, and they analyze your genetic outlook and background. So for folks who are customers or users of that service, they sent out a notice that they had changed their privacy policy, and they included an email address that you could reply and ask them questions about the changes. So Johannes, being someone who actually pushes back on these things, did just that. And he asked them, what changes did you make? And why did you make these changes? And why aren't you publishing the changes in addition to the new version? And 23andMe got right back to him and said, we have published the changes. And you can log in, you can view the changes along with the full version of the privacy. And he told them why they made the changes. It's our privacy policies were reviewed by trustee to ensure that their programs meet those requirements. And so we'd like to just let people know that. And so when you go to the link that they sent Johannes to, they have a wonderful few pages long, bullet points, single-spaced, but very readable, just saying we added the definitions, etc., exactly what changes were made. It's not redlined, but it's highlighting the changes that were made and letting people know rather than just blindsiding them with it. So the tip is to do your privacy policy changes in this way. Let people poke back on it. Let them be informed about what's changing. Don't just slip it in without notice, and you won't get in trouble. So congratulations, 23andMe, for doing a good job on that. And then our resource of the week comes from David Sparks' site, Spark Minute. And I liked this because it's titled The Top 10 Things You Didn't Consider When Developing Your Social Media Strategy. And actually what I like about it is that it doesn't include the various legal concerns that I'm used to hearing about first off when companies are considering their social media. It's very practical. The number one point, the one I probably like the best, is that blocking social services is moot. You've got to just decide that if your company's not using them, your employees are going to be, and then you go from there. So it's some great tips about integrating social services into a corporate environment in an effective way. And we thank David Spark for his great site and this good resource. And with that, I'm going to go around and ask our wonderful panel if there's anything else we haven't covered they want to touch on, anything else they want to discuss before we wrap the show. Iyaz?
No, I don't want to go into a rant anymore about notifications. It's just become a real sticking point. Like I end up walking around the house talking about notifications. I don't know how people are ever going to know what they're agreeing to. Even if they had that bullet point thing, as you had in the tip there, it still requires them to sit there and read it. And I don't know what the solution is. Branding people? I just don't know what it is. I'm just wondering what the practical application is. So if you have any ideas, hit me up on Twitter or something and let me know, because I'm just confused.
Great. Well, Iyaz, we've had a great time chatting with you on the show today. Thanks so much for joining us. and for taking time away from doing all the other stuff that you do at TWiT, including Tech News Today and In Other News, and Just a Minute with Iyaz, although you were saying you haven't done those for a while. But
yeah, so if you're watching TWiT today, I'm going to be on pretty much everything. Tech News Today at 2:30, and then immediately after Tom's finished recording Tech History Today, we'll be doing Another News. But if you want to follow me, you can check out plus.iyaz.me. That's a quick way to get to me on Google+, because that's really where I post. I don't really post a whole lot on Twitter as much. So thanks for having me, guys. It was a great discussion. I learned a lot, so that's always great. Thanks, guys.
Thanks. We loved having you. Kevin, it's been great having you back as well, and hope that everything's going great in your neck of the woods and you enjoy a wonderful holiday.
Well, thanks. Same to you.
You want to tell us if there's anything else that you want to let our listeners know about going on in your world or your life? Any issues we didn't cover today?
Oh, nothing major going on that I think we haven't covered. I think there were some things in the show notes that we talked about possibly covering, such as people misusing copyright for abusing Yelp reviews and so forth. I think those were good articles. And so if people get a chance to read those in the show notes, I think that's certainly good to go. I just did a webinar on Wednesday for my firm on online works and their protection and so forth. If anybody's interested in watching that recording, they can do that at our firm blog, which is blog.davismcgrath.com/webinars. And it's sort of a fun thing to put together for people, the free 30-minute, overview of different intellectual property topics. So that's kind of fun. Beyond that, I'm looking forward to the holidays. I wish everybody a great and safe one and safe travels.
Great. Thank you so much, Kevin. Evan, wonderful to have you back on the show. I know we didn't quite get into the Section 230 Yelp issues. Maybe we can do that at a later date. They just seem to keep coming up. And it seems to be dentists. Dentists seem to get really ticked off about what people say about them on Yelp.
Yeah, I've dealt with a number of dentists and Yelp and online reviews in my own practice, and plastic surgeons, don't like Yelp too much. So I don't know what it is about the the dentists that deal with the face somehow. So Yelp gives us no shortage of Section 230 questions. So yeah, they'll be fun to talk about at some point. So as far as plugging anything, I don't really have anything that I'm working on myself. I just know the holidays coming up. Sometimes we tend to get a little blue. So I wanted to, I've talked about this before. I think everybody knows that I'm a big fan of awkwardfamilyphotos.com. With the holidays coming up, there's so many family pictures. There's some great, they're just burning it up over there at awkwardfamilyphotos.com. Really, really funny stuff. So I have nothing to do with the site, no reason to plug it other than I laugh out loud every time I go there. So great stuff coming out these days.
So Evan, you haven't contributed a picture yet?
Well, maybe I shouldn't say one way or the other, and you can just peruse the archives and see if you find me.
I'm sure the audience will Photoshop something.
Evan, this actually seems like an opportunity to build your practice, since you've been representing people who've been on the wrong end of getting posted to Is Anyone Up? It seems like, a similar kind of thing, because people get hundreds of Christmas cards, holiday cards each year. And, I don't think anybody identifies their own necessarily as awkward, but I could certainly go through my stack and find several that I think are worthy of that site. So
yeah, it's great for that. And it's also great for a good, dose of nostalgia, circa 1982, because it's like a lot of folks, 20, 30s, early 40s somethings, submitting this stuff. So it's like, there's a lot of good retro content on there as well. So you gotta love the web.
I think they've done a real public service, because I think in the wake of that site, you'd be hard pressed to find a photographer who would actually suggest that people do that kind of dog pile on each other sideways photo. That's so wonderful when you see it there on that site. So thank you, Awkward Family Photos, for sparing us from more of those. And thank you, Evan. And the whole panel for a great time today on This Week in Law. We'll see you soon. Before we go, I want to just let you know you can hit me up on Twitter. I'm at Howell there. I'm Denise at twit.tv. Love to hear from you between the shows and love to hear about the topics that are on your mind. TWiL's got a Google Plus page where you can interact with us, and also one over on Facebook. And we post the episodes there and talk about the links that we're getting ready to discuss on the show. So that's another place I love to hear from you to help us get together and decide what's important to all of you to talk about in the world of law and technology, because that's what we're all about here on TWiL. So until the next time, we'll talk to you later. Take care. Oh God, that makes a terrible noise.
That was something.
And yeah,
I don't know what, but it was something.
It was festive, is what it was. Saxy Santa.